profits of multinational companies cannot be located in tax havens.
Hello, good afternoon. We are extremely delighted to welcome with us Pascal Saint-Amans, the head of tax policy unit for OECD, but more importantly, person who's championed the cause of OECD BEPS project. Welcome, sir.
Thank you.
Since you're in India, I just wanted to, kind of ask few questions which are very specific to emerging markets and then to India as well, now that you've been so deeply involved in negotiations with emerging markets. You would have, best part of your career dealt with primarily OECD nations and treaty related. What has been your experience dealing with conflicts between the OECD and the emerging markets as a part of the BEPS project?
Well, first, I'm very happy to be in India, even though it's too short to visit, but I'll be back soon. And second, at the OECD, actually, we have been working with the G20 non-OECD countries, which are emerging markets, for quite a long time. One of my deputies is Indian, Monica Bhatia, so we are working very closely with them. Are there that many contradictions between OECD countries and emerging economies? Within the OECD, we have emerging economies, Mexico, Chile, and some others. That said, it is true that the perspective of a country like India or China or Brazil is not the same as Germany or the US, which are pure capital exporters, even though emerging economies now are also exporting capital, and you have more nuanced views than a pure developing country, which would just be an importer of capital. So the BEPS experience has been about reaching compromise, reaching common understanding of the challenges of today's world. And there was one thing on which everybody would agree upfront, which is that the money, the profits of multinational companies cannot be located in tax havens. So there may be a disagreement on how much the market should get out of the profit of the multinationals, but for sure there is an agreement between the US and India that it shouldn't be in Bermuda.
Correct.
That's for sure. So that common approach helped tremendously. And then the second step is we are in a globalized environment, and if we want to attract investment and if we want to collect the revenue, these are maybe sometimes conflicting objectives, but they shouldn't be conflicting. We need to have common rules. And of course, when you disagree, you need to talk and you need to reach the common ground. And I think we've been extremely lucky to have very much political involvement from the leaders, from the finance ministers, and very good civil servants, technocrats, conducting the negotiation, Akhilesh Ranjan in this country in particular, who have been very smart in terms of reaching common agreement with the US and other countries.
And any areas of disagreement or misalignment that you'd like to talk about which still remain unresolved, because we are still yet to see the implementation steps?
Well, actually, I would start with what has been agreed. 15 actions have been agreed. Imagine 3 years ago, 4 years ago, when we launched the BEPS project, who would have thought that we would have 15 actions agreed on transfer pricing, on tax treaty, on the definition of the permanent establishment, on anti-treaty abuse provisions, on hybrid mismatches, on interest deductibility, on the country-by-country reporting. There is agreement, there is full alignment. Now, we may say that on the digital economy, even though there was agreement on VAT, and that fits, by the way, the reform that you've just introduced on VAT and services in India, but except for action 1, where there are things which were left open for countries to decide, there was broad agreement. On the way forward, we'll be looking for similar agreement, noting that India, the US, China, Germany, the European countries and the others all agreed to open up the Committee on Fiscal Affairs, where the BEPS work was carried out, to all developing countries which are interested and stand ready to commit to BEPS. So now the dialogue, the conversation, will no longer be between OECD and G20 countries, but between OECD and G20 countries on the one hand, I would say, and developing countries on the other hand.
Let's come back to India. We have a fairly evolved judicial system. So many of the issues that you're dealing with as part of the BEPS project, whether it's got to do with anti-avoidance, treaty abuse, substance test, transfer pricing. We have the maximum number of transfer pricing decisions, and we have a fairly evolved, judiciary that renders good quality advice, which is now quoted in many other international courts. Do you see that, in light of where the country stands today, implementation of BEPS would become easier or more complicated? Because in India, there is often a say that disputes never get finalized till the time they go to the final court of law. Do you see a fundamental difference in the way India will implement it and other emerging markets will implement it, where the court system is not as evolved? So let's take a case of digital transactions, action point 1. We already have a plethora of court decisions on what constitutes PE in the context of digital transaction. So, any views on that?
Well, indeed, I mean, you've set the scene pretty well. You have a judiciary system which is very reliable and looked at by many countries as being good, and as very often telling disant le droit, we would say in French, meaning telling what the law means in a way which is agreed internationally. So there is a lot of respect, I think, for your judiciary system. On the other hand, you're right to point to the fact that India, or the Indian Revenue Authority, has a reputation of being tough and of taking time to change its opinion when it can change it. And I think this is due to some reasons which are related to the civil service in India and to the ability of civil servants to take decisions, which may be related to the perception of corruption, and so which make people extremely careful in what they do. So in this situation, at the end of the day, taxpayers know that the rule of law will prevail because the judiciary system is good. They may have conflicts with the tax administration in between, but I have to say also that the tax administration is improving dramatically, that you have extremely good people around here, and that by getting more involved in the international negotiation, in reaching compromise with other countries, in, for instance, agreeing the minimum standard on Action 14, which is about eliminating double taxation, this may probably result in a behavioral change and in global improvement of the situation in India. So does it make life easier or more difficult for taxpayers? I think the judiciary system obviously makes it easier for taxpayers, maybe more difficult for the revenue authorities, but the increasing incorporation or the increasing integration of India in the global community, I think, is a good sign. And your civil servants, your upper civil servants, are extremely good in moving into that direction, which will secure investments in India.
Action point 14 that you talked about, I know much has been talked about arbitration, but I think the preamble to action point 14 suggests that it's the improvement of MAP process. And this is an area where India has received a lot of flag in the past with some of its large trading partners. Two questions I have on action point 14. How do you see the MAP process improving? Is your answer the peer review process? And second, given India's position now that it's not going to embrace mandatory arbitration, where do you see the arbitration issue ending up? Do you see India adopting the UN regulation for non-binding form of arbitration and not the mandatory arbitration?
Clearly, Action 14, which is a minimum standard, is aimed at ensuring that countries will be serious at eliminating double taxation. For decades, they have not been that good, and that's why the number of cases which should be solved has, skyrocketed. And it's not only India. India has a bad reputation here, but you're not the only ones. I could mention Germany, I could mention Italy, and some other OECD countries which are not doing great. Why is it the case? Even though in international conferences we've been talking about how can we improve arbitration, how can we improve mutual agreement procedures, nothing has ever come up. I think there are a number of factors, of reasons. The first one is, at a time where companies are extremely aggressive in their tax planning, it's not the priority of tax administrations to eliminate double taxation where there is double taxation. That's no excuse but that's a reason why things were not done. Second, if you're the tax commissioner of a country, your priority is not to put resource on something which will cost you money and which is not in your core business, which is to collect the taxes in your country. So the international team dealing with MAP was not on the radar screen of the tax commissioners. And the BEPS project, I think, will be a game changer. It will be a game changer because first we have a minimum standard, which means that it will be reviewed. There will be a peer review. But it's not the review itself which will get countries change, which will get tax administrations more serious in eliminating double taxation. It's the fact that the reviews will be made public and will be reported to the G20 finance ministers and to the G20 leaders. And that's where tax commissioners, I think, will put mutual agreement procedures on their radar screen because they don't want to be ashamed to their prime minister, to their president if they don't deliver there. And that's these mechanics of minimum standard peer review reporting to the G20, which I think will result in a behavioral change. On top of that, you could say, well, arbitration will help. Yes, it would. And I regret that India is not moving there. I understand the sociological reason why India is not yet moving into that direction. But I'm confident that if we are serious in dealing with the mutual agreement procedures, arbitration would not be needed. Doesn't mean that we shouldn't have it. We should have it in the multilateral instrument. It should be binding. It should be compulsory, not to be used. You know, arbitration is there so that it's a deterrent effect which will push countries to solve MAP, but there is this peer review which should address that. Now, what about the UN initiative you're referring to? It's welcome and work well with the UN. If countries want to test arbitration by not having it legally binding, so be it. I don't believe in it much because it's a question of attitude. You go or you don't go. You don't, test the water. Is it too cold to jump or not? You jump or you don't jump. But what matters today is to make sure that we'll be able to improve mutual agreement procedures. That's a commitment taken by all G20, all OECD countries in the context of the G20 work. There will be a review, and this review should result in behavioral changes.
My last question, what do you see as important milestones from your BEPS implementation standpoint in the next 3 months, in the next 6 months? In particular, several people have questions on the outcome of multilateral agreement. Would you like to share views?
It's all about implementation of the BEPS package in a consistent manner in a broad scope. So we did build this inclusive framework for BEPS implementation. We will have, I think, by the end of January, 100 countries on an equal footing, which includes all the OECD, all the G20, and many developing countries, which means that we level the playing field. That's one. Second, implementation by countries of their commitment. Country by country reporting is becoming a reality. Companies have to fill the form now at the end of 2016, or for India, as you have a calendar year, a fiscal year which is slightly different. In the second half of 17, you will have to fill this in. That's implementation by countries and by companies. Implementation through the negotiation of this multilateral instrument, which will amend the bilateral tax treaties. 98 jurisdictions negotiated this multilateral instrument. I am confident that by the end of November, the text of this agreement will be agreed and it will then be open for signature. I hope that as many countries as possible will sign, because that will be a direct implementation of the minimum standard on Action 6. And as regards the OECD Secretariat work, we need to ensure that we start the peer reviews on Action 5, harmful tax practices, on Action 6, on treaty shopping, on Action 13, on the country-by-country reporting, and we've talked at length of the mutual agreement procedure, which is Action 14. But with that, we also monitor the way countries implement transfer pricing rules and the way country translates into their domestic legislation all the other measures. So you see that there is a lot to do with many countries, plus keeping on the discussion on very important projects, profit split, allocation of profit to permanent establishment. BEPS has been, I think, a game changer in international taxation. It's not the end, it's the beginning.
On a more lighter note, when it comes to BEPS project, what keeps you awake in the night?
It kept me awake at night for the past 3 years, so now I sleep better because everything was agreed. It's more implementation, it's less challenging, so I sleep pretty well.
Well, you were listening to Pascal, the chief architect of the BEPS project. Many people joke, or rather there is a side conversation, that there couldn't have been anyone better to lead this important project. And why is that the case? That's the case because he's the only one who can deal with tax administrators of emerging markets, developed markets. He can reconcile views between civil servants and politicians. All the best, Pascal. It's a pleasure talking to you.
Thank you. Pleasure. Thank you.